Hello again, and welcome to another episode of Ask the Lawyer. I'm Rob Rosenthal with AskTheLawyers.com. Well, summer might still be fresh in our memories, but it won't be long before it'll be time again to think about snow and ice, especially in the northeast part of the country. And with snow and ice often comes slips and falls. Well, today we're going to ask the lawyer about the responsibility a property owner has to keep their property in safe condition. And here to answer our questions is attorney Kate Reilly of the law firm Brady Brady Reilly, based in the Newark, New Jersey area. Kate, thank you for making some time and being here with us today. I appreciate that.
Thank you. It's my pleasure to join you.
So let's start off. When can a property owner be held liable for injuries? Someone comes on their property, they have a slip and a fall. When is it the property owner's liability?
Well, the primary thing we have to look at is the status of the property owner as well as the parties involved. There's a distinction in New Jersey about commercial property versus residential property. The residential property owner does not have the same duties and obligations to a person who falls on their property as a commercial property owner would have.
Okay, and so what duties, what is the difference? What responsibilities does a business owner have?
Well, the duty of care is the same, and that is that they have to use reasonable care under the circumstances. Snow and ice cases require proof of the weather on the date, say 24 hours before the accident happens, and the weather going forward from the time the accident happens. Commercial property owners have a higher duty because they generally, for instance, supermarkets, they're open. They invite people to come to their property, and they have a duty to keep their sidewalks clear, to make sure they put salt on the walks so that they're safe for people to walk on or through their property. The residential homeowner, property owner in New Jersey has different responsibilities. If they don't create a condition, such as installing gutters that cause rainwater to go on the sidewalk, which could then freeze and cause a condition different than regular drainage, then the homeowner could be responsible under those circumstances for someone who fell and was injured on the property. But generally speaking, the residential property owner, where they actually reside, cannot be held responsible unless they do something that would change their duties. The commercial property owner, on the other hand, has the responsibility to keep it clear and to be able to prove that they've done that.
So let's focus on commercial property then. What is necessary? What has to be proven in order to, in those sort of cases?
Well, we've got to see, the first thing we need to know was what the weather conditions were like. When did the snow start? When did the snow end? Had there been any snow before this snow? Because then we'd be looking for snow on top of ice. So if there had been an ice condition that was present and then it snowed on top of that, such as something you wouldn't obviously notice when you're walking on the sidewalk, that presents a problem for the commercial property owner and enables us to be able to prove a negligence on their part in the manner in which they clean their sidewalks or their parking lot. We want to look at maintenance records to see whether the parking lots were plowed, whether salt was put down. We go looking for video of the parking lot or the area where an incident occurred to see what the conditions look like at the time of the accident. And again, when did the snow stop? And did they use reasonable efforts from the time it stopped to clear those sidewalks and put some ice melt or something down to keep it from refreezing and causing dangerous conditions that would cause someone to be injured, fall and be injured on their property.
So of all that, what is the most difficult element of that to prove in a slip and fall case?
Well, the difficulty comes in proving the conditions as they existed when the injury occurred. So, for instance, if someone falls but doesn't report the accident or doesn't have pictures to depict the conditions when they fell, our job is much harder. We're going to go back and get weather records from different businesses that maintain them and hopefully find video. Many of the stores today do maintain video. But again, if a client doesn't contact us right away, that video might not have been preserved. So preserving the evidence that shows the condition that led to the fall is one of the biggest battles that we face, because we need to prove that the condition was not reasonable under the circumstances.
So it sounds like advice when you're in an auto accident, take lots and lots of pictures. Sounds like in this sort of situation that would also be beneficial.
Absolutely. The pictures can show the condition. Someone could deny it, but if there are pictures that illustrate the condition of the property and where actually the client fell, that makes an enormous difference in our ability to prove the negligence of the property owner.
It would seem that, well, first of all, it seems like, would you advise that they get some sort of medical treatment as soon as possible in those situations?
Well, absolutely. If you fall on property and you're injured, you have to document it. So whether you go to the emergency room or whether you go to a doctor, somehow you've got to, first of all, get treatment for your injuries. And second of all, document that this is when it happened. If someone fell and there's a gap in treatment, the property owner's going to argue, how do we know what happened during that intervening period? Could they have been injured in some other way? So it is important that you document how you fell and when you fell, as well as to make sure that you discover what injuries you suffered as a result of that fall.
Are you likely, I would think, maybe especially in the case of like a big grocery store chain or something like that, are you likely to have some contact, get a phone call or something from their insurance company wanting to talk to you, maybe get you to sign some papers?
Well, generally speaking, assuming that you report the injury to the supermarket, they're going to take down your name, your phone number, your information, and oftentimes they do reach out. And it's important that clients realize that you don't want to give them any more statements. You don't want to give them any more personal information without first consulting with an attorney. Because especially in the hours after an accident or the day after an accident, you may be in a condition, you may be taking medication. It's important that you consult with an attorney and know what your rights are, and not rely on representations made by especially larger commercial property owners as to what your rights are or what they can do for you.
It would seem that some people might think, Kate, oh, it's just a fall, I'm fine, maybe I have a bruise, I don't need to contact an attorney. It sounds like maybe it's the kind of thing, let the attorney decide whether or not you need an attorney, whether your case is viable or not.
Yeah, it's important on two levels. First of all, the consultation is free. So you have nothing to lose by consulting an attorney. At least here in New Jersey, a personal injury case, the consultation is free. So you come in, you find out what your rights are. Secondly, oftentimes our clients may have a back injury, may have a shoulder injury, and they're hoping it's going to go away. But we've learned as time passes, those injuries may get worse and may require surgery. So if the property owner wants you to waive your rights for some type of a nominal payment in the beginning, you're endangering yourself and limiting yourself when you really don't know how badly injured you are. So it's important to be evaluated, to get proper medical treatment, and then make a determination as to how best proceed. And the best way to do that is to get some advice from a personal injury lawyer.
And it sounds like you're saying as early in the process as possible, especially when it comes to that preservation of evidence and that sort of thing, get somebody, rather than wait, oh, I'll wait a week or two and then I'll call. It could be way too late by that point.
Absolutely. There may be video at the scene. If we don't write to the property owner and tell them that we are demanding they preserve the evidence, we're at a loss, because if they don't have it, we can't prove what those conditions really look like. And often I have been in the situation where a client came to me a year later and there was no video preserved. And then it's a he said, she said. It's a very difficult case to prove. Whereas if you have pictures and video evidence right there from the day the incident occurred or that week, you're in a much better situation to prove what the condition of the property was as it existed on the day of the injury.
Kate, that's lots of helpful advice. I do appreciate that. And thank you for giving us some time today. That's going to do it for this episode of Ask the Lawyer. My guest has been attorney Kate Reilly of the law firm Brady Brady Reilly, based in the Newark, New Jersey area. If you want the best information about premises liability, or you're ready to choose a lawyer that lawyers choose, be sure to visit askthelawyer.com. Don't forget to subscribe to our YouTube channel by clicking on the button at the bottom of the screen so you don't miss any future episodes. Thanks for watching. I'm Rob Rosenthal with askthelawyer.com.